Welcome back, guys. Thanks for watching. Please like, subscribe, and share this video. Today I want to talk about the Electoral Count Act of 1887. What is this law? And why is the GOP and Mitch McConnell so willing to agree to this one tiny change? Is it to get out of voting in favor of the Freedom to Vote Act and the John Lewis Voting Rights Advancement Act, while still getting the optics and appearance of bipartisanship by carving out and fixing this obscure, hard to follow, difficult law of 1887? I'm going to play a few clips explaining what the law is, the text of the law.
3 U.S. Code 15, Counting Electoral Votes in Congress. Congress shall be in session on the 6th day of January succeeding every meeting of the electors. The Senate and House of Representatives shall meet in the hall of the House of Representatives at the hour of 1 o'clock in the afternoon on that day, and the President of the Senate shall be their presiding officer. 2 tellers shall be previously appointed on the part of the Senate and 2 on the part of the House of Representatives, to whom shall be handed, as they are opened by the President of the Senate, all the certificates and papers purporting to be certificates of the electoral votes, which certificates and papers shall be opened, presented, and acted upon in the alphabetical order of the states, beginning with the letter A, and said tellers, having then read the same in the presence and hearing of the 2 houses, shall make a list of the votes as they shall appear from the said certificates, and the votes having been ascertained and counted according to the rules in this subchapter provided, the result of the same shall be delivered to the President of the Senate, who shall thereupon announce the state of the vote, which announcement shall be deemed a sufficient declaration of the persons, if any, elected President and Vice President of the United States, and, together with a list of the votes, be entered on the journals of the 2 houses. Upon such reading of any such certificate or paper, the President of the Senate shall call for objections, if any. Every objection shall be made in writing, and shall state clearly and concisely, and without argument, the ground thereof, and shall be signed by at least 1 senator and 1 member of the House of Representatives before the same shall be received. When all objections so made to any vote or paper from a state shall have been received and read, the Senate shall thereupon withdraw, and such objections shall be submitted to the Senate for its decision, and the Speaker of the House of Representatives shall, in like manner, submit such objections to the House of Representatives for its decision, and no electoral vote or votes from any state which shall have been regularly given by electors whose appointment has been lawfully certified to, according to Section 6 of this title, from which but 1 return has been received, shall be rejected, but the 2 houses concurrently may reject the vote or votes when they agree that such vote or votes have not been so regularly given by electors whose appointment has been so certified. If more than 1 return or paper purporting to be a return from a state shall have been received by the President of the Senate, those votes, and those only, shall be counted which shall have been regularly given by the electors who are shown by the determination mentioned in Section 5 of this title to have been appointed, if the determination in said section provided for shall have been made, or by such successors or substitutes, in case of a vacancy in the Board of Electors so ascertained, as have been appointed to fill such vacancy in the mode provided by the laws of the state, but in case there shall arise the question which of 2 or more of such state authorities determining what electors have been appointed, as mentioned in Section 5 of this title, is the lawful tribunal of such state, the votes regularly given of those electors, and those only, of such state shall be counted whose title as electors the 2 houses, acting separately, shall concurrently decide is supported by the decision of such state so authorized by its law, and in such case of more than 1 return or paper purporting to be a return from a state, if there shall have been no such determination of the question in the state aforesaid, then those votes, and those only, shall be counted which the 2 houses shall concurrently decide were cast by lawful electors appointed in accordance with the laws of the state, unless the 2 houses, acting separately, shall concurrently decide such votes not to be the lawful votes of the legally appointed electors of such state. But if the 2 houses shall disagree in respect of the counting of such votes, then, and in that case, the votes of the electors whose appointment shall have been certified by the executive of the state, under the seal thereof, shall be counted. When the two houses have voted, they shall immediately again meet, and the presiding officer shall then announce the decision of the question submitted. No votes or papers from any other state shall be acted upon until the objections previously made to the votes or papers from any state shall have been finally disposed of.
Okay, so next I'm going to play a clip from Ali Velshi from MSNBC explaining the history of the law and giving us some context of what and how it plays in our modern day political discourse. And then I will be back with some more commentary for you guys about Mitch McConnell, the GOP, and Democratic response to the desire to correct, fix, whatever you want to call it, of the Electoral Count Act of 1887.
Few of you probably think much about Rutherford B. Hayes, a Republican who served one relatively inconsequential term as President of the United States. Fewer of you yet probably remember much about Samuel Tilden, his Democratic opponent in the 1876 election, yet they are both suddenly quite relevant to our current debates about the future of American democracy. The presidential election of 1876 set into motion a tradition that is now at the center of the January 6th insurrection. You see, that election is actually the most disputed in U.S. history. The showdown between Hayes and Tilden was rife with actual voter fraud, intimidation, and efforts to, wait for it, suppress the black vote. So-called white rifle clubs massacred black residents to frighten others into not voting. Democrats, who had been the pro-slavery party during the Civil War, convinced landlords and shop owners to charge a surtax on anyone who was even suspected of voting Republican. And Republican operatives were suspected of stuffing ballot boxes and throwing out Democratic votes. It's said that votes were being sold for $5 apiece, equivalent to about $130 today. Now, days before the inauguration, it was still unclear who, Hayes or Tilden, would take the oath of office. 3 southern states, Louisiana, South Carolina, and Florida, claimed election fraud and disputed their own elections, each of them sending 2 competing slates of electors to Capitol Hill to Congress for them to pick from. A commission was formed to decide the winner, but because there were more Republicans on the commission, Rutherford B. Hayes was ultimately sworn in, despite Tilden having won the popular vote. Now, Congress ultimately acknowledged that maybe this wasn't the most democratic process, so over the next 10 years, Congress debated and eventually passed something called the Electoral Count Act. And this is where things get interesting. The Electoral Count Act was meant to set guidelines for how Congress settles a disputed presidential election. But the language is so confusing, vague, and almost unintelligible that it leaves much to interpretation. Regardless, the bill and its progenitors faded into relative obscurity for more than 100 years. No one took advantage of the easily manipulated legislation until 2021. In the days leading up to the insurrection, the former president's allies devised a plan to use a warped interpretation of the 1887 Electoral Count Act to try to overturn the results of the 2020 election. In a memo obtained by the January 6th committee, John Eastman, a former lawyer for Donald Trump, tried to persuade then Vice President Mike Pence to reject Joe Biden's legitimate victory when Congress met to certify the election on, you guessed it, January the 6th. We all know what happened next. Pence, by good fortune, chose not to bow to the pressure of the failed president and not to perpetuate the big lie. Instead, the then vice president affirmed the Electoral College count, thereby formalizing Joe Biden's victory. Who knows what would have happened if Mike Pence had decided that power trumps democracy that day? And I'd rather we never find out. After what we experienced last year, there's a real fear of states finding loopholes to override the will of voters. And mocking those fears last week, Republican Senate Minority Leader Mitch McConnell said, and I quote, "Why would any legislature in America want to overturn the counting of votes? They have to get elected by those people too. The notion that some state legislature would be crazy enough to say to their own voters, we're not going to honor the results of the election, is ridiculous on its face." End quote. I don't know, Mitch, But that's exactly what a bunch of state legislators tried to do. And these 147 members of your party in the House of Representatives and the Senate supported those efforts by voting against certifying the legitimate victory of Joe Biden on January 6th. A recent UMass Amherst poll finds that 71% of Republicans still don't believe that Biden was legitimately elected the president of the United States, not because of voter fraud, but because of the big lie. Despite this, there's now bipartisan support, by the way, for reforming the stupid 1887 Electoral Count Act to clarify that the vice president does not have unbridled power to discount electors, among other possible changes. McConnell says, surprisingly, that he's open to fixing the Electoral Count Act. But McConnell's probably betting that a bipartisan effort to fix the Electoral Count Act, as important as that is, will just distract from the far more comprehensive election reform that's being mapped out by Democrats that neither he nor any other Republican senator appears to have any interest in supporting. Now, regardless of the politics behind it, the Electoral Count Act needs reforming or eliminating. But that alone will not prevent American democracy from backsliding. There are, as I said, two other far more comprehensive efforts in front of the Senate that will really address the anti-democratic impulses that are coursing through America right now. The chance to fix this problem is now, before we actually do lose democracy.
Mitch McConnell a little bit and his history. McConnell's modus operandi throughout the years in the Senate has been to block, stymie, or otherwise avert changes to the federal election law. Any law that he believes that would put a disadvantage on Republicans. In his view, anything beyond the status quo, whether it's the transparency in elections, or easier voter participation, they all must be treated as a partisan attack and defended. Mitch McConnell said, aside from all other things they're discussing, they, meaning the Democrats, this is something that is worth discussing in an interview to Politico this past Wednesday. Speaking about the law, the Electoral Count Act of 1887, McConnell says, it obviously has some flaws, and it is worth, I think, discussing. He said that in an interview to Politico on Wednesday. You know, it's funny that he's so willing at this moment to do that when you can go back and look back in 1990 and 91 and 92. Mitch McConnell was absolutely opposed to the National Voter Registration Act, an act that helps people to be able to register more easily while they are renewing their driver's license. To get more people to participate in our democracy, which is a good thing. McConnell was just very unhappy with this. And he did everything he could to try to block it. He threatened twice within that year to use the filibuster because he thought that it would add millions of Democrats to the rolls. McConnell said then, in the phrase he used, a solution in search of a problem. Well, in September, McConnell used that same language, those same exact words, to push his users, his caucus, I guess is how you would say that, his caucus, to not vote for this act, by saying, again, a solution in search of a problem. Now, there have been, because I want to be fair, there have been a couple of rare occasions where McConnell has been on board with new federal election laws. In the aftermath of the 2000 presidential election of George W. Bush, McConnell helped draft a new bipartisan deal on what would become the Help America Vote Act. And in 2004, he supported primary reauthorization and pre-clearance provisions of the Voting Rights Act, which requires states with a history of discrimination and disfranchisement to get Justice Department sign-off on changing any of their laws. McConnell, who was the majority whip at the time, and the majority leader, Bill First of Tennessee at the time, went on record supporting the preemptive reauthorization of the key selection of the Voting Rights Act. Senator McConnell and I want to make it clear that America will never renege on the hard-fought gains of the civil rights movement. First said, we don't want anyone to fear that their rights to vote will ever be taken away. McConnell said, the protections in the Voting Rights Act are, frankly, too important to provide only a temporary basis. When the Senate unanimously reauthorized the act in 2006, McConnell said he was pleased the Senate reaffirmed that our country must continue to progress towards becoming a society in which every person of every background can realize the American dream. But when the Supreme Court ruled in the Shelby County versus Holder in 2013 in a 5-4 decision, the court gutted the pre-clearance requirements, but left the door open to Congress to restore it. See right there, to Congress to restore it, and it did not happen. That provided McConnell a cover. The cover he needed to shift and then say, I don't want big government involved. Instead of backing a law on the books, he would now oppose what he framed as new federal overreach. And that's the same thing he's doing continuously since 2013, going back on his previous statements. What was struck down were the provisions that absurdly treated the South differently, McConnell said in a 2016 interview with USA Today. They don't apply anymore. It's 50 years later. But a quick fact check, you would find that this precondition clearances also applied to counties in New York and California, not just the South. They were not being treated differently. It was states and counties who had a history of discriminating and disfranchising certain people to vote. So why now is McConnell so willing to take up reforms in the Electoral Count Act? Because he knows that offering the chance for a bipartisanship win is a tempting way for moderate Democrats to stand beside him. A standalone bill on the Election Account Act would snap the unified Democratic support for the Freedom to Vote Act. Moreover, the kind of bipartisan cooperation would also be likely undercut any movement towards reforming the filibuster to carve out an exception for voting rights, leaving red states free to make the ballot box as inaccessible as possible. In layman's terms, McConnell is saying, what if instead of giving you a pepperoni pizza, I give you a stick of pepperoni and we call it square? It's not enough, guys. We need voting rights to be protected. We cannot allow these states to continue to disfranchise people from being able to vote. I want to give you a little perspective on what some of the other Republican senators said. So Senator Mike Rounds, a Republican of South Dakota, said, it's too early to know if the fresh discussion will translate into legislation. I've heard early that some members were at least going to look at the possibility, but whether or not the actual translation into legislation is yet to be determined, he said in an interview. And how long that takes and where that fails in the political where that falls in the political process here at this stage of the game with everything else going on, I'm not sure what else is going to see that coming up in the near future. This is one of those things which has time before it comes up, rounds added. Senator Rick Scott, a Republican of Florida, was non-committal on the changes of the 1887 statute. Whatever comes up, I'll go through it, is what he says. Centrist Susan Collins of Maine, a Republican, said she was completely open to revisiting the 1887 law and is working on a proposal to do so. For one thing, I think that we need to clarify the role of the Vice President and make it clear the Vice President cannot overturn the electoral results. If former Vice President Mike Pence hadn't been so strong last January 6th, or if we had a future Vice President who wasn't as strong, we need to make sure the law was clear, Collins told NBC News on Wednesday. That's just one example. Senator Pat Toomey, Republican of Pennsylvania, who was retiring from Congress in 2023, voted to convict Trump on impeachment charges last year, also expressed interest in some changes to the 1887 law. I think you could make a good case that we sought to revisit the statute. I think if I remember correctly, it's very old, he said. It should be very, very clear that Congress's role is a ministerial one. That might benefit from an update. So, this is where we're at with the Republicans at this moment. They are saying, okay, we'll give you one tiny little carve out of what you want, and we'll talk about this 1886 obscure law that had never been used since it was created in 1887 until the Republicans tried to steal the election in January of 2021. So I'm going to also play a clip after my commentary on what the Senate Majority Leader Chuck Schumer had to say. I think that Democrats realize that this is a poison pill, that if we do this and we have this standalone bill, we're going to give Republicans the optics of bipartisanship when they're actually refusing to cooperate within bipartisanship. Luckily, the Senate Majority Leader, Chuck Schumer, Democrat of New York, seems unwilling to take the bait. He promised debate and consideration changes to the rules by January 17th, Martin Luther King Jr. Day. If Republicans continue to stand in the way of the two voting rights bills, Senate Majority Leader Chuck Schumer said that he would carve out from the filibuster. He also said that revisiting the 1887 law without protecting access to the ballot box makes no sense whatsoever. If you're going to rig the game and then say, oh, well, count the rigged game accurately, what good is that? He said Tuesday. Some scorekeeping matters little if the game is rigged, Chuck Schumer said. White House spokesman Andrew Bates said on Wednesday about the changes to the Electoral Count Act is no substitution for bolstering voting rights and calling the GOP senators to stop doing dirty work on behalf of the big lie of the stolen election in 2020. The president has been crystal clear that the pending voting rights legislation, the Freedom to Vote Act, and the John Lewis Voting Rights Amendment Act are essential to protecting the constitutional right to vote, the rule of law, and the integrity of our elections against un-American attacks based on the big lie, Bates said in an email to NBC News. There's no substitution, period. Joe Manchin, Democrat of West Virginia. Anything that we can do to enhance the process to make it much more secure is something we should take a look at. When asked about the changes to the 1887 law, moderate Democrat Joe Manchin, Democrat of West Virginia, and Kristen Sinema, Democrat of Arizona, also endorsed looking at the law, but a number of more liberal Democrats did not. instead of making it clear that the Republicans' interest in reforming the counting process is a way for the party to avoid engaging in other structural protections of voting rights, which is an insane thing, that they're willing to address the way they count the rules, the votes, the certification after, but not protecting the right to actually get every American to the poll to vote is absurd. Ned Foley, an election law expert with the Ohio State University, said it's especially important this year. It's time to address these problems. The time to address these problems is now, Foley said. Now is the maximum vein of ignorance, where the two political parties don't know exactly what the lay of the land is going to be in 2024 and 2025. And so there is a greater chance of bipartisan censoring on the clear procedures of governing the process. So I'm going to end this with a clip from Rachel Maddow and Chuck Schumer. I will post a list of links in the description box where I've gotten all of my information at for this video. Thank you guys so much. Please do like and subscribe. I do appreciate your time here with me, and I hope we get to spend more of it together.
One of the things that has emerged in the last few days is that the Republican leader, Mr. McConnell, has reportedly suggested that he is open to one small piece of the package of reforms and the package of protections that you and your colleagues in the Biden administration support in terms of protecting voting rights, that he is potentially open to supporting reforms to the Electoral Count Act to try to prevent the limited procedural shenanigans that gave them their theory of the case in terms of why the Capitol attack happened on January 6th. Just wanted to get your reaction to that apparent movement from Senator McConnell just on that one piece of those reforms and protections that you've been pushing for.
Well, let me say this. I think that what they're trying to do is try to substitute that for the very needed reforms that we have urged, undoing what the state legislatures are doing throughout the country. And so it's sort of like saying, well, I'm going to rig the game, but then I'll make sure you count the score accurately. But what the hell is the point if you rig the game to count the score accurately? So that's point number one. Point number two, it doesn't deal with the House or Senate. The Electoral College only elects the president. So it has nothing to do with any elections in the House and Senate which they're trying to rig into jaundice. And third, what they're trying to do is accomplish things in a different way. Donald Trump wanted Pence to rig the election. This law might say, well, let's let the state legislatures rig the election. Neither is good. So I think this is a fake. I think it's a way to try and get the two senators that we have who are not on board to go for something that won't change the horrible, voracious change in the balance of power that will allow elections to slant things in the directions of Republicans in a dramatic way, in an unfair way, and in an small d democratic way, and I'm opposed to it. I'm opposed to allowing it to be the subject of this conversation. They want to talk about that later and reform the Electoral College, fine, but it's no substitute for what we have to do.
And in terms of what you have to do, you've put a specific timeline on this now. You've said that by the Martin Luther King holiday, by a week from Monday, you want to vote on potentially changing the Senate rules or carving out some sort of exception from the way the Senate rules are right now in order to be able to pass the voting rights protections that you support. Tell me about the decision to put that specific timeline out there, to create that expectation about when this is going to happen. Tell me about your confidence that you're going to be able to get the vote that you want.
Well, first, we're running out of time. What these legislatures have done in 2021 and are now beginning to do in 2022, if you wait much longer, you won't be able to undo them in time for the 2022 elections. Even if the Even if the legislation says what they did is wrong, the courts may say it's too close to the primary season, we can't change it. So we have to move quickly. But second, requiring a vote on both the rules changes and on the actual legislation, the Freedom to Vote Act and the John Lewis Voting Rights Act, says to each of my 50 senators, you are going to have to make a decision. The spotlight of history is on you. Are you going to side with the forces that are dramatically undoing our elections, preventing the right to vote, a giant step backward, certainly in the last 50 years, maybe even longer, in terms of our democracy? Or are you going to do the right thing? And I think when the spotlight of history and the weight of history is on the shoulders of all 50 members, the hope is that they do the right thing. Is there a guarantee? No. But we are going to have a vote. Have to, and we will.